done best.
Don't have a bailiff, so thank you. Well, we could have had a bailiff. My two research attorneys are back there just twiddling their thumbs. Okay, you may be seated. There went my, watch out, Leslie, I just dropped my finger. Okay. Good morning. I'm Karen Arnoldberger of Kansas Court of Appeals. I'll be the presiding judge today with this panel. All that means is that I get to take time. And as I tell people, I am really bad at it. So I will do the best I can. If I end up giving one side a little more time because I forget to look at my watch and I didn't bring mine. You did, thank you. See, I can't even bring the necessary stuff in here. All right, several of you have been before us many times. So I probably don't need to go into this, but first let me introduce who's with me. To my right is Judge J.C. Hurst, who at least currently hails from Lawrence. And to my left, Judge Leslie Isherwood from Wichita. And so we are very excited to hear the cases today. We were here all day yesterday hearing cases. It was a great time. We've read your briefs. We've read the record in a lot of cases. So you only have, I think all of these are 15-minute arguments today. Don't waste your time going over lots of details on the facts. because we know them. Okay, we promise, and we'll ask you questions if there are factual issues that come to pass. I am going to first call and make sure everyone's here. So we'll know that we're going to stick with the same order. And then if you were the appellant in the case, if you just let me know if you want to reserve any time. So we're going to start out with in the matter of the marriage of Chapman.
Just Booth for Stephen Chapman, reserve 5 minutes for rebuttal.
That's okay.
Sharon Chapman by Ronald Nelson.
Okay. And Tiffany Spires versus City of Wichita.
Thank you, Your Honor. Matt Bretz on behalf of the plaintiff. I'd like to reserve 3 minutes.
3, okay.
And Nathaniel here, Tommy Johnson.
Okay, thank you. And then the case that gets the award for the best name of a caption case that we've had in a long time. Beehive Honey Hole versus Rockin' G Roofing Systems.
All here for the plaintiff or appellant, and I would like 3 minutes for rebuttal.
Okay, thank you, Mr. Powell.
Jeremy Taylor for
Okay, thank you. Good. We'll stick to this order then. Everybody's here. So, Mr. Booth, if you want to go ahead and come up here, you can, we'll start the timer as soon as you get started.
Thank you, Don. Seems like more times I'm in front of you, the closer I get.
It is intimate here.
Yeah, to kind of do a makeshift.
Well, we're all friends, Mr. Nelson and I. Number,
Well, I was gonna say, I think you two have been opposite each other.
even when we were partners.
It's probably, yeah, even when you were partners.
I digress. Thank you, Your Honor. This case rubs, of course, against the abuse of discretion concept, which is our biggest guide stone when it comes to decisions that are apt for mere property. But it breaks the banks of that fairly quickly, starting with the idea of how things were structured in the pretrial order. And the pretrial order, of course, is so controlling that you can usually take a pass on comments made like everything should have been split in 2005, et cetera. And that was actually counsel's choice. They didn't go back and rebut and talk a lot about what happened in 2005. And there were several good reasons for that, including one that is predominant, and that is there was no evidence presented about what happened in 2005. All we know really is that the parties went from cohabiting to not cohabiting. A lot of talk on Mr. Chapman's choices and his disclosures. Not a lot of talk in the decision about what Mrs. Chapman thought about the whole thing, other than she didn't want a divorce. And when he filed for divorce, they worked through it and they didn't do it. They didn't split up their property. They had separate property as far as what we call separate property before the filing of a divorce. And they had commingled property, namely that Raymond James account. And when you take the Raymond James account, it was a joint account. The court made a specific finding that there is no basis for. The finding was that she was the sole contributor to that joint account. He testified that he had put in some 150,000, I'm using round numbers, early in the days. Remember, this was a 20-year marriage. Yes.
When did he put in? I was trying to see the evidence specific to that account. There is evidence of deposits in the account. But none for that deposit.
So far back in time that it predated when her expert was able to get documentation. It was his testimony that she never rebutted. She had a rebuttal for other transfers and said, I never saw a deposit for this or that. They all predate this. And that also just belies
He's an expert though too, right?
Right.
Did his expert find that deposit?
No, they both followed the pretrial order and they were all looking in 2021, 2020, around the time of the filing and trial. So nobody was doing archaeological surveys to try to find out what was happening back then. But what we have here is he at least testified that there was a contribution. She didn't contradict that contribution, that early contribution. And beyond that, it really doesn't matter. As a couple, going back to the idea that we have separate property while we're still married,
Mhm.
as a couple, they chose to make this a joint account. And, you know, we've all been in the conversation where somebody's individual account, a 401k or an IRA, those were all contributions by myself. Well, of course they were. You know, you and your employer got together, created tax consequences for that, and it's always just in one name. But there's nothing in a 20-year marriage in which we put things together, when we cobble it together on the filing of the divorce, that says that just because you robbed Peter to pay into your 401k doesn't mean Paul got a little taken away from him too. And so, you know, we just hold no quarter for the idea usually that one person over a 20-year marriage contributed everything to a particular account when it was marital resources. We constantly, and I'm demonstrating this over and over again, and what I'm sharing this morning, we're constantly dancing between this contradictory stance that we have in the law, which I think is a very healthy one, that says married people have individual property and individual rights, and their spouses can't take their money, nor can their spouses' creditors. But when we go to looking at breaking up the marriage, we see it as a community effort, and we bring things together. That's the point in which we're most together, is when we're trying to get the furthest apart. So it's an interesting little contradiction, if you want to call it that way, or a way that we do equity.
I know one of the issues is, you know, did she change the valuation date from 2021 to 2005?
Yes.
Would it make it, does it all come out in the wash, so to speak?
No, because you're making decisions. First of all, you're making decisions in dividing an estate you know nothing about.
Mhm.
We don't have a value for the Raymond James account at the time of the 2005.
But when the parties can't reach an agreement as to how to divide their property, you turn it over to the judge
Right.
to make the best decision he or she can make based on the evidence before
Right.
them.
And that's,
So ignoring which valuation date was used, what was untoward about her final outcome?
contradicted her own evidentiary findings.
Mhm.
She said the basis for her for Sharon getting all of that Raymond James account was that she was the sole contributor. And at the same time, in the same document, she acknowledges that he enriched that account by $500,000. We skip between the two dates. Somehow we get amnesia when we go back to 2005, but you can't ignore the fact that the couple treated that as a trend and treated it as their account. He's living in Kansas City, Missouri. She's living in Johnson County, and he's working the account, increasing the value. And she testified that she often had no idea what was going on in those accounts. Talk about trust. Talk about liability of
This is
very
the most amiable split in all other ways, I think.
yes,
I've ever
yes,
seen.
very, very intelligent, caring, compassionate people.
Isn't it true, though, that we don't have to divide this account equally? We don't even have to divide it by what each of them put into it.
As
I mean-
long as we're not arbitrary,
Right.
capricious,
Yeah.
yada, yada, yada.
At the end,
Yes.
we have a reasonable division of property, right?
Equitable.
Equitable, reasonable under the circumstances.
Certainly. And you can't come up with an equitable distribution if you don't know what the parts are. Here we're painting with such a broad brush that we really have no idea. And then it spills in when you look at the trailing issues, including the fact that the court charged him for the taxes on the account she set aside to her. She testified the right thing to do would be for her to pay for the taxes. But the court, even on reconsideration, didn't charge her for her own taxes on her own account that she supposedly was the sole contributor to. It's as though the court blamed him for making money in the account and charged him for the costs of making that money.
Well, is there any credibility and sort of blame that is permissible to go into the district court's decision?
It's so limited because it's not dissipation, and that's our main thing.
Mhm.
Dissipation of assets has its own set of criteria, and if he was accused of anything that was untoward, it's that he parted company and moved over to Missouri after declaring that he was gay. He's,
Purchases, weren't there some purchases?
there were some purchases, a number of things that they bought back and forth. Lots of attention on whether or not he used their joint account. Remember, it's their joint account, so why would he have any idea why he was doing one thing or the other?
It seems like that became the heart of the disagreement is when he was buying properties and she didn't know it. Is that,
That was a big
I mean, it seems like everything's
flag.
pretty agreeable.
But if you look at it this way, he was not using the Raymond James money to buy the property. He was using his inherited. And he's sitting in Missouri. If he would have moved that into joint, it would have converted to joint. If he would have suffered a Missouri divorce, he wouldn't know. He's a lawyer, so he might think about it, but he wouldn't know. In Kansas, we're going to trace that equity a little bit more equitably, which is the counter side to exactly the issue you just raised.
Mhm.
But there was nothing wasteful about instead of having Apple stock, having condominiums, et cetera. And the only thing that wound up at issue there was the condominiums had the tax and HOA loans against them, which he rightfully argued, if you're going to net out what these assets are. So here we have netting out of these assets and blame and conversation for 2005 to 2021 conversations. And that's all loading this decision that says we're going to forget about all that. They apparently parted company in 2005, which wasn't true.
Did
But-
they actually, I mean, when I look at the numbers that were actually used for the values,
Mhm.
the court said, we're setting a value date of this. Okay, and then, sorry about that. They were actually the 2021 values, right?
Correct.
Okay, so the court didn't actually use a 2005 valuation date,
Well, it said it did.
right?
Okay.
So,
So the court said,
and
sometimes I say things and that's not the word I meant. But the actual values that were used for 2021.
the spreadsheet was 2021. There was talk about assets after that, but when she awards Raymond James, she just basically sets it over as though he had no contributions, and therefore it was as though it was a premarital asset in 2021. And what we're looking at is litigating 2021 to 2025 instead of date of marriage, which was 20 years before that, to now. And this relationship isn't defined by which chapter, the two chapters being nearly equal, but the first half or the last half. All we do know is that he offered a divorce in 2021. They decided not to. Or I'm sorry, the earlier date, whatever that's,
Right.
05. And then they stayed married and vacationed, co-invested.
So what's the bottom line money wise? I mean, how much does he, I mean, it comes down to money. How much what's the total amount he believes he should have been given and wasn't?
Well, we don't know the value because it is the 2005.
No,
No,
use the
use
2021 value.
Yeah, use the
Was-
current.
If you divide it and award her the entire 2005 asset, or you can say the value
Let's
is,
assume she
21.
did it like you wanted her to
Right.
do it.
it would be the value of the Raymond James account minus her inheritance.
Which,
He would-
but how much are we talking?
It was 100,000. If I recall.
So $100,000 discrepancy is the case.
She inherited 100.
No, I know. I'm just saying if you had gotten everything you wanted.
You were faster than I was on the math.
Yeah.
300, 200, 100.
Yeah.
Gotcha. Yes. And then on top of that, we have this.
I just want a total, Mr. Booth.
Well,
What is your idea of what, if things if he had gotten X number of dollars, we wouldn't be here today. That's what.
It is the half of the Raymond James account that's
How,
Of the half.
minus 100.
Okay.
It is going back and ignoring this transfer and adjustment for the money that went into the interest-bearing account that was never proven to have ever gotten out of the.
okay, you have to know just what are we talking
Yeah.
about? I mean,
But he's got a debit against him for half that value of the, what was $375,000 that went into the high interest bearing in Schwab. He showed the exhibit 3D, I believe it was called, and he's still charged for half that.
So I'm gonna ask it one more time.
Yeah.
So this journal entry
Right,
that Judge Mason entered,
right.
cheats him out, I mean, just of how much money? I just want the math, just the total,
Okay.
how unreasonable was this?
She got the entirety of the Raymond James and then.
Okay, I don't have those numbers in front of me. I just want you to.
Just a total,
Just-
just a total.
I-
You have to have some idea what it is you would want to happen when you go back. What should have happened?
Approximately $300,000 because it's built from three elements. primarily.
Okay.
And that is charging him for money that wasn't missing and they couldn't prove was missing and
Okay.
he showed was there.
So she got $300,000 more and he got $300,000 less.
Yes, when you combine those,
Out of this. That's all I want to know.
and then on top of that, we have him paying her income tax to the tune of about $40,000 on her asset that was reported to.
Okay, so.
You reverse.
340 now, we're at.
So but I need to back that one off in total candor, because if you split the Raymond James account, then the tax decision logically would be different too.
Okay, all right. I just want to
Pay all of her taxes if she gets all of the assets, if they
Just
split the assets.
ballpark. That's all I'm.
Mr. Booth, please, for the love of it all, just answer the question.
Yeah.
A number. I don't need it broken down.
I think we're right at that
About 3 or 3.
around the
Okay.
300,000.
All right, just, thank you. I think you're out of
It's all my alarm.
I'll still give you your rebuttal because we started asking questions right at the end of your time. So, Mr. Nelson. Mr. Booth doesn't have any hair left. Mr. Nelson all has hair. That's what being a family law practitioner does to you.
Exactly.
You both have a special place in heaven.
True.
There are a lot of wild hairs in this case, and one of the wild hairs is the valuation date. Judge Mason used the valuation date that these parties agreed to and included in the pretrial order,
Which was which year?
which is 2021.
Okay.
It is, we admit in the brief that Judge Mason misspoke. She said, I'm going to use the date of valuation as 2005. It's not what she meant. It's not what she did. She used that as the date of division. She said, the two of you separated in 2005. You accumulated things after that time. And you agreed to all these things on what to do with them, how to do what with them, and who got what. And so I'm going to deal with these issues that you have not been able to agree to, these properties and these particular matters. And she went through meticulously on each one of those and said, this is how I'm doing it. This is what I'm doing, and this is why I'm doing it. She ultimately put the division spreadsheet as an attachment to journal entry and said, given the division that I have said, this is how the numbers break down. That's unequal. That is disparate. It is widely disparate. That is my decision. Mr. Chapman requested that I divide everything equally.
Thank you.
Apologize.
Yeah.
Thank you, but just so you know, I think it locks, which is.
Yeah,
don't
so Ms.
cut it all the
Jackson, if
way.
there's any way,
Yeah.
yeah, thank you. We learned yesterday that once it shuts, it locks and nobody can come in. Okay,
Now I can't.
okay, I'm sorry.
Judge Mason said these are disparate
Yes,
and
and she understood that.
one of them.
She knew that.
Mhm.
And she said, that's my intention, to give a disparate division of assets.
Doesn't sound like Mr. Booth wants an equal division. It
What-
sounds like he wants, because 300 grand extra wouldn't equal them out.
That's what they asked for at the trial court. That's what they asked for at the motion to alter or amend. That is what they wanted. That is what they have always said, is an equal division. And because Judge didn't give me an equal division, I don't think it's fair. I don't think it's appropriate. I don't think it appropriately divides everything. And that was the motion to alter or amend, was he brought the same thing to Judge Mason on the motion to alter or amend. And the judge said, I considered all this. I looked at all this. I paid attention to all of those things, and this is how I divided it.
Now, are we, I mean, we're discussing this 2021 versus 2005. In all fairness, the judge did say more than once that the valuation date was 2005.
I did.
And so are we just ignoring that? I mean, how are we sure that it was the 2021 date?
Well, because that's the date that was used on all of her numbers, one on the spreadsheet, two elsewhere. And she said, I'm going to look at 2005 because that's when they separated and started accumulating their own things. Now, one of the things that Mr. Booth indicated, one of the things that was an issue at trial and afterwards was the talk about marital versus individual property. There's no such thing in Kansas.
There is no such thing.
There is marital property once the divorce is filed, and everything is divided as the judge determines is fair, just, and equitable, given all of the factors in the individual case, and it can be widely disparate. It doesn't matter when the property was obtained. It doesn't matter how the property was obtained. It doesn't matter the value of the property. It matters whether the judge believes the particular division that the judge finally ends up with by agreements and by the court's own decisions, whether the judge looks at that and says, well, I need to adjust that, or, well, it's not equal, but it doesn't matter because that's what I think is fair, just, and equitable. And that's what the judge did. She didn't go back and say these values in 2005. She said each of the parties had various assets that they handled as their own after their separation in 2005. There was a joint account that she contributed to after 2005, and that considering everything, I'm going to give that to her. There were things that Ms. Chapman requested be divided equally or be given to Mr. Chapman, but the court said, no, I'm doing it a different way. I'm giving either Ms. Chapman asked that he be given something and the court divided it equally or gave it to her, or the other way around. So the
point is, the judge put a lot of thought into this. It wasn't just a rote.
It is not what I.
Now, this Raymond James account, I mean, at least for a period of time, he was taking a payment out of that account.
He was.
As well. And was that calculated? The fact that there was already some that if we say that's all her account, he did get some benefit from that account.
Get some benefit from it. Because he was taking money out of the
And
rent.
it was all by agreement. I mean, it's
It was all by, well, it wasn't necessarily by agreement, but it wasn't by it was over an objection. And
well, I think she suggested it. She suggested,
Yeah.
I'm going to take 2,000 a month to supplement my income. And why don't you take 2,000 a month out of that account too? Okay.
And so there were, that was the specific account.
Right.
But there were other
Right.
matters like that because she didn't want a divorce. She didn't want this marriage to end. She loved Mr. Chapman. She cared about Mr. Chapman.
I think it's clear they both cared a lot about each other.
Very much. Very much.
I mean, this
And it
is
was
amazing.
It was an unfortunate situation, but what the court looked at was, yes, this was an amicable situation. Yes, Ms. Chapman bent over backwards because she loved Mr. Chapman. And Mr. Chapman did all of this either without ever talking to her, and he didn't have to do that. We don't have to do that in marriages. We don't have to talk to our partner about that. But she was fully open with him, and he wasn't for whatever reason. And the court said, and Mr. Chapman, Mr. Booth, focus on there's no dissipation. Dissipation's not the issue. There was no allegation of dissipation. In the pretrial order and from the beginning of the case, Ms. Tilges for Ms. Chapman said, this is the valuation date. This is the date of all of the things in 2021 when the petition for divorce that ended in a divorce decree should be valued. But everything should be divided as of 2005 when they started accumulating things.
He's saying I can't ignore this split in 2005 because that kind of tells the story better. So,
Yes.
but you're saying the actual valuation dates were 2021.
Correct. And that's what the court used on its valuation spreadsheet. That's what the court referred to throughout its opinion on values and other items. And Judge Mason discussed what happened with individual items throughout her 39-page decision.
Right.
And said, that's what I'm doing. That's how I'm
Justifying
in this to my satisfaction of what is an appropriate and fair division.
In briefing this, how much money did you think was at dispute? Like if we were able to fix it exactly how we wanted and say, this is the correct award?
I don't know, because our position is that the judge did just what she should have done.
I know, but you read their brief and replied to
Yes.
it. And so in doing that, how much more money do you think he wanted? You hadn't thought about it?
I hadn't really thought about it.
Okay.
Because there were so many parts of it that, not simplifying it, but nitpicking everything that wasn't his way, wasn't equally divided, wasn't divided as of the date that he wanted it to be divided, because he didn't want it divided in 2005.
Well, it wasn't divided as of the 2005 value,
Right.
right? It was divided as of the 2021
Yes.
value?
Yes,
Okay, okay.
but it was,
The separation date was considered as a factor regarding the,
how
how
they'd
how
intermingled.
they,
how it was to be divided, who was to get what, and what factors were to be considered as a result of that, and as a result of all the properties, the 8 condominiums that Mr. Chapman purchased, which goes to the taxes that were discussed, which Judge Mason specifically addressed and said, these are taxes for real estate. These are taxes that came out of that account. No, I'm not going to credit you, Mr. Chapman, with those taxes. Those were yours. And there are so many things like that Judge Mason looked at and did. Everything is addressed in my brief. Really, from our standpoint, it comes down to there was a request for an equal division of everything from Mr. Chapman. There was a request of an unequal division as of a certain, starting as of a certain separation date, and then with the values looking at 2021 to see, okay, how does that line up? But Ms. Chapman never asked that that final valuation be equal and never considered whether it would be equal or not. It was how it's divided is what matters. And I'll stand on my brief for the other issues.
Yeah, time. To write up.
Any further questions?
Big to try to challenge an abuse of discretion on a judge that has all of these different moving parts.
Right.
You agree? So why does this case, why did Judge Mason get it so wrong that she abused her discretion?
It was primarily in moving.
And do you think it's a legal error because the valuation date or, okay,
Yes, most specifically, it's that. We went back and asked, it wasn't that she misspoke. She justified the reason for using the 2005 separation date by saying, when asked about the date evaluation, why did you move the date evaluation? Did not answer the procedural questions about how you moved the date evaluation, gave people due process, just said everything went to that 2005 separation date. Just about the entire case was about separating in 2005 and what the parties did after that. That's Record on Appeal 36, pages 5 and 6. So she's saying, I purposely moved the valuation date to 2005. She used 2001 numbers to render a valuation date of 2005's decision. And from that, she had no evidence. None of the experts had anything. They couldn't find the records for it. There was very little testimony about what happened other than they no longer cohabited.
There was testimony that about this one account that since 2005, the only deposits were from Ms. Chapman, right?
Yes,
Okay.
that's post 2005, which is past the valuation date the court uses. The door is closed. Now we have chatter about what happens after that. It's filling in all this information on what to do with the 2005 valuation date, except for we don't have any value of the 2005.
Well, so doesn't that more lean towards she wasn't using it as a valuation date? She's just using that as a point in time to start gauging the party's conduct, just as Mr. Larson says, that we just want to see what their behavior was past that 2005 point. To me, if there's no evidence of anything that could be valued, that leans more towards that was her intention, not evaluation.
Well, she expressed her intention differently. You know, sort of like what we just had in a conversation, for the love of God, Hunter, why did you do this? And she said, because everything rolled back to 2005 and the entire trial in her mind was for what happened after 2005. I purposely changed the valuation date because I thought it was appropriate, missing all the rigor of 216.
Okay, so we agree, say we agree with you, and we send this back. She takes all the evidence, comes up with the same decision,
That's happened to me before.
right?
It's happened to me before.
All
But
right,
we may know why.
yeah,
You know, questions like, how does somebody contributing $500,000 to the other person's estate just get ignored? How does it just go away?
And that is the increase in value from
Right, that
his management.
he managed.
right.
Nope,
Except that you said you're not looking for $500,000.
we're splitting the account. And if you split the account, it includes that growth.
Right.
And the way we came up with that math was 100,000 was inherited. That leaves 2, which leaves 1 each. And then we talked about that double dip, the 300,000 for the cash account.
Okay.
That circles the story around pretty well. Other elements rely on this whole business of how the assets are split and what the load is against. If we're splitting all the assets, his load with the taxes and homeowners association for the condos gets a different flavor, and so does the income tax off of her Raymond James account that he wound up paying for, even when questioned by the court, over her sense of what was a fair or not share. I think I've about burnt my time up.
Yeah.
Yep, you have. Thank you very much.
Thank you.
Thank you both. Great briefs, great argument. We appreciate it. These cases are never, never easy. Okay. You're the same debonair guy. Okay, Tiffany Spires versus City of Wichita.
Thank you, Your Honor. May it please the court,
Yeah.
counsel. This is an appeal, as the court knows, of a case arising from a sidewalk in Wichita that had been neglected for 30 years.
You're looking to her because you know she's from Wichita and she's probably ridden that same.
Yes, and because she was on the Court of Appeals during the, when the,
The Zagor, whatever. Zaragoza.
yes, when that,
Zaragoza.
So this is just you and I now.
They under,
but this is
were you on Zaragoza? Yeah.
at the Court of Appeals level, yes.
Oh, yeah, I mean, I know.
Interestingly, was it, language she used was adopted by the Supreme Court. Quote,
Oh, I know, we know.
this is a sidewalk that goes from downtown to the Linwood, South City neighborhoods. And there are a lot of things the court knows that can happen on a sidewalk. People can walk to work, they can do physical therapy, they can have a river festival once a year. And just like the courthouse, and I use this example because I've been at the courthouse when they come in, the carolers come in at Christmas time, a courthouse can be used for caroling at Christmas. It doesn't make it a recreational facility. And while people can do a river festival once a year at a certain part of this sidewalk, this is a city sidewalk between downtown and a neighborhood to the north and between two neighborhoods to the south.
The area the injury took place in was the part of the water walk area though.
There's a hotel there.
Right, I mean,
And there is a park nearby. You can call it loosely a park. It's a large circular space, but it's a city sidewalk. But that's really not, I don't want to concede that this isn't, or I don't want to concede that this is a recreational area, because I really think that the courts over the years have expanded what the statute says.
and they certainly, in Zaragoza, I mean, you have a really hard time trying to get past immunity here in Zaragoza, given the facts of that case. I mean, that was a sidewalk in front of a library.
It's a library, and I was planning to argue about Zaragoza because I don't think it applies at all. In fact,
And why is that?
it wasn't a published decision at the time that the case was in front of the district court.
Well, the Kansas Supreme Court decided it.
Right,
Right. So
Right,
you
but-
have a published case.
right. It wasn't.
The sidewalk in front of the library is recreational use.
Agreed. We have that. It wasn't published at the time of argument at the district court. And frankly, I wasn't aware of it. It wasn't cited in their brief or wasn't produced
Right.
beforehand. And it's 41 pages long,
Mhm.
which I tried to skim during oral argument. But what I found after reading 41 pages, it has nothing to do with this case. The Zaragoza case dealt with a sidewalk and a curb and a gutter and a drain, just like we see on every block in Kansas and most places around the country where there gets rain. And in every sidewalk with a gutter and a drain, there's a potential for somebody to step in the drain. And in Zaragoza, everybody knew, the city knew, the library knew, everybody knew that there was a sidewalk and a gutter and a drain, just no one thought it was dangerous. That's a very different situation than we have here.
So sidewalks are inherently dangerous.
More dangerous than a walk and
A
a
gutter and a.
That was part of the problem in Zaragoza, because this is an ordinary sidewalk with a gutter and a drain. No one thought this is dangerous. It's normal.
And how is your sidewalk not normal?
In this case,
Uh-huh.
the defense concedes that it was dangerous and that it put people at risk of injury or death. And the reason it was dangerous is because the city created this condition. The city planted cypress trees of all things, not crimson pygmy barberries. They planted cypress trees in a hole this big immediately adjacent to the sidewalk, knowing that those are fast-growing trees and that this was inevitable. And as you would expect, you plant a big tree like that right next to the sidewalk, literally inches away.
Was there evidence of that, that they did this intentionally and they knew it was inevitable, but
Yes.
gosh be darned, I'm gonna plant it anyway?
There was evidence in the record that these are fast-growing cypress trees. There was not a city commission meeting notice that said, note that said, we're choosing to put in trees that are going to push up the sidewalk. But they did approve cypress.
But you said knew it was inevitable.
These are cypress trees. Botanists have known, the public knows that cypress trees are fast-growing. And you put an oak tree next to a sidewalk, you put a cypress tree next to a sidewalk, it's going to do what we have all seen in.
I haven't looked at the record in this case, but I'm assuming there were cypress trees all up and down this walkway.
There were.
Was this the only place?
Nope. There are other places where the ledge along the water literally had broken off and fallen into the water. It was missing for years, just like this. But, unlike in Zaragoza, the city created this. The city concedes that it was dangerous. In Zaragoza, the city never conceded it was dangerous because it's a gutter and a drain like everywhere else. But the part of Zaragoza that the defendant didn't read, apparently, because they didn't cite the whole sentence, they cited half of a sentence. The part of Zaragoza that actually helps the plaintiff is the part that was adopted by the Supreme Court from the Court of Appeals decision. And it reads, to constitute wantonness, the act must indicate a realization of the imminence of danger and a reckless disregard. That's the half of the sentence that they quote. The rest of the sentence says, quote, or a complete indifference or an unconcern for the probable consequences of the wrongful act. So it's either or. Ignoring for 30 years, a jury could conclude that that is complete indifference or a concern for the probable consequences of their act. Having their own survey done that was in their possession, they produced it to us during discovery, having their own survey done that shows this defect and doing nothing about it. They said, well, we didn't look at it. Well, isn't that something that a jury conclude is complete indifference when they have a survey done that shows this defect, that shows the broken wall that's fallen into the water, and they do nothing about it?
When was the survey?
It was done the year before, 2021. It was done the year of 2022, and was done the next year, 2023.
But doesn't,
But it didn't show the area, didn't show damage to the area.
It did.
Plaintiff was injured.
It did. It is on their own survey, and that's set forth in the expert reports, or expert report, I should say. It's set forth in our statement of additional controverted and uncontroverted facts that they didn't even respond to. And that at the hearing.
how this goes to the, I mean, this seems to be going to gross and wanton negligence.
Absolutely.
But, and you can get past the immunity if you get to gross.
Exactly.
I guess, I think you have a really hard time getting past the immunity, the first step.
Sure.
So, but what you're talking about is it's gross and wanton because
Absolutely.
they've known all along.
Yeah, I would argue that the courts have wrongly expanded
Nothing we
recreational
can do
use.
about it.
Right, there's nothing we can do about it, but it's gone far beyond what the legislative language says. But if a library is recreational use, then a sidewalk that
In a riverwalk area.
downtown to a neighborhood, then a sidewalk arguably is also a recreational use. I mean, my kids painted on the sidewalk with chalk, so maybe that's recreational use. But
So it seems like that, to me, the crux of your argument is what they did was gross and wanton.
right. There is evidence from which a rational juror could conclude that there's gross and wanton negligence. their own survey shows this defect and they don't look at their survey, or if they did, then they had actual knowledge. Either way, we get either the first half of the sentence from Zaragoza or we get into the second half of the sentence from Zaragoza.
Okay, and so you're saying that there were other places where those trees had cracked the concrete?
Yes,
That's in the record?
it's in the record. It's in the expert report that is attached to the opposition to motion for summary judgment.
Now, is it the concrete of the sidewalk that's cracked, or is it like down the hill, like along the water?
Both. The concrete is cracked, and this is not just a crack.
No.
Yeah, it's not just the crack, but it's also the wall. And that's where the roots from these trees look for water.
Right.
And they found water in the river.
But
It's pushed over the wall.
No, I was just,
Yeah.
I wanted to clarify, and I don't mean to talk over you. I'm
No,
sorry.
sorry.
When you said there was other damage, whether there was other damage to the sidewalk or whether the other damage was in reference to the wall, but you're saying that in addition to where they fell, that there was other similar damage?
Yes.
Somewhere.
And this damage, yes, and this damage was so bad, it wasn't just that there was a crack in the sidewalk. The roots had come through a couple places when they excavated it and found that the roots had pushed up both sides of this slab that's right next to the tree. And then that had caused the middle to crack and the middle to fall. So someone coming along on a scooter with a tiny little wheel first hits something that stops that wheel and then finally gets over it and then goes down when they get to the trough in the middle. But, you know, additional things that the jury could, or a fact finder could find are gross negligence is the city has people who go to this location within 10 feet twice a week to empty the trash can.
But that's a different, I mean,
Yeah, those aren't inspectors.
those aren't, well, right, they're not inspectors, and the people that empty the trash are not likely the people that are in charge of doing some sort of assessment of the integrity of the sidewalk, is my guess.
That may be. They're city employees though. And whether it's a trash worker or a police officer who's a city employee, it's knowledge to the city. The city has conceded that they knew that they had a mandatory duty, and it's set forth in the PIC instructions and Kansas Supreme Court cases. And the city conceded in the depositions that they knew they had a mandatory duty to inspect and maintain, and that they didn't. In fact, they didn't even have an inspection program. Is that my time?
It is.
I talk a lot.
You can finish your thought.
They didn't even have an inspection program. And in depositions, they didn't know which department was supposed to do inspections. A jury may conclude, a rational fact finder could conclude, that if there is this duty and they don't do anything, that's again evidence of gross negligence. They didn't do anything for 30 years. For things that are shown on their own surveys, and the defect is shown in satellite imagery as far back as imagery is available, 2017. Thank you.
Johnson.
Thank you.
Thank you, Your Honor. Nathaniel Viertaler Johnson with the City of Wichita. I mean, we agree with the way you phrased the question. We think this is a fairly straightforward application of the recreational use exception, especially after the Zaragoza decision. We understand that it came out during the decision, but I think it should probably still be cited on appeal in the brief and dealt with very directly in that way. That case controls the situation. We think this was a recreational use area. It was an open area for recreational purposes. It's a bike path. That's what their expert says too. Judge is aware of that. I use it with my brother the same way all the time. Riding an e-scooter along it. It's along the river. It connects to a variety of different parks. And under the broad definition of recreational use adopted by the Supreme Court at several times,
And so why wasn't this gross and wanton?
And I think that's the key question. Thank you. It is not gross and wanton negligence because the city did not have specific knowledge of the danger that was posed to the plaintiff in this case. And we think that and I did read Zaragoza, we cite the whole sentence actually in the brief, and we cite not only that sentence, but the district court judge quoting that whole sentence as well. And Judge Johnson went through each of the pieces of the evidence that were presented here and did not find that it rose to the level of establishing specific knowledge by the city. I think the key first thing to address based on the argument by appellant is this survey. I'm not entirely sure what he means by survey. Based on the briefs, it seems to be the survey that we do of all properties for our GIS maps. So we do satellite imagery of the entire area. The city has one, the county has one. They're all over. They establish what properties are what, who's in what district, things like that for the public. That's not an inspection program. And the city does not review every piece of satellite imagery from GIS to determine cracks in the sidewalk. We have a lot of sidewalks. We have a good amount of bike paths and are expanding them as we go all through the city, connecting all around. And the city, unfortunately, does not have the resources to inspect every single piece of pathway.
Yeah, but not having the resources has nothing to do with gross or wanton negligence.
But and fair, Your Honor. I think that it does get to the idea of why it's reasonable for us to establish our program based on complaints from individuals, though. And that's the basis for that. And we think that is a reasonable approach. And the district court, Judge Johnson, found so as well.
So, go ahead. No.
Even in areas that are very much used for this, I mean, you say we have lots of bike paths all over the whole city. Some of them are clearly not attached to the actual recreation area of this Riverwalk area, right?
True, that is true.
They're through other parts. So we're not talking about far distant ones. We're talking about a place where events are held and things are done and people change the trash. There's a trash can.
For sure.
Why not in those areas?
Why isn't there a heightened duty?
Yeah,
in
how
those
is
areas?
it not?
Oh, I understand, Your Honor. Thing. Yeah, it's the same recreational use area. And the city, again, relies on complaints. And in higher use areas, we do receive more complaints. It was described as kind of a huge issue, but as the district court judge found, there's kind of a concave in the concrete. And there's pictures in the record. I've got one here from the petition. It's not kind of the tree roots coming up or anything like that. It's a dip in the concrete. And we hadn't had any employees and he talks about 30 years, we hadn't had any complaints about this issue or the specific danger posed to plaintiff in that entire time.
So
that is what we do our best to respond to.
How do you respond to Mr. Brett's statement that you guys concede that you had a duty to maintain it, but failed to do so? Is that just a general overarching, yes, city property, we would obviously have an obligation to maintain it? Or what I get from him is that this was more of a targeted concession. How would you respond to that?
Yeah, I didn't understand it as a targeted concession. We definitely didn't concede anywhere that cypress trees are uniquely dangerous and need to be ripped out from everywhere there along the sidewalks. The city does have a duty to maintain its streets and sidewalks, and that is not questioned here. And I think that comes through maybe in the pattern jury instructions that the appellant cites, where all of those track ordinary negligence, what it is to establish negligence for failing to maintain city streets and sidewalks, but not gross and wanton negligence.
And it may have been ordinary negligence, but it also.
That is true, Your Honor. And that's not something that we necessarily got into, but based on the standard in Zaragoza of having to have specific danger, specific knowledge of the specific danger posed to the plaintiff, we just didn't have that. And there's no evidence of that here.
Is, what do you say to the idea that the people who changed the trash cans should have seen this and are, responsible for seeing this and are city employees, et cetera?
They have a lot of trash cans to pick up, and that's their duty. They're not trained to inspect for sidewalk safety or street maintenance, which seems to potentially be the suggestion. A unique quirk here, too, was the evidence in the record is that the trash can's a little bit obstructed from where this dip in the pathway is. So it's also not something that they necessarily would have seen, even if they were trained on it and still doing their job of collecting trash. And that's just not an obligation that we put on those employees, or we think even maybe if it gets to negligence, doesn't establish that gross and wanton negligence that's necessary to overcome the recreational use exception. And really, that's really the main part here. And we think a variety of cases kind of demonstrate that. In the brief, appellant talks a lot about how negligence needs to go to the jury, but Zaragoza was summary judgment dismissal prior to going to the jury. So was Lee versus City of Fort Scott and Robinson versus State that are cited by the court. The one that's cited by appellant is Gruen, which is cited in Zaragoza, but distinguished from those facts. And in that case, a golf course property had a hole that someone fell into before. They only put chalk around the hole, someone fell in again. That was specific knowledge. I'll talk to our golf people actually after that one. That was gross and wanton negligence, or at least sufficient to go to a jury. But in all these other cases, not. In Levers, excuse me.
And I don't know, maybe I could just be making things up, but is there like, in the medical practice and negligence, it says what's within the standard, the medical standard of care, is there a city sidewalk standard of care out there that was discussed, or
And maybe I'm answering this incorrect.
Not necessarily what Wichita did,
Mhm.
because maybe Wichita's actions were way outside the norm,
Mhm.
which would go to gross and wanton. So
There's no evidence of the record of other municipalities or governments doing something different than our inspection program.
right.
There's no comparison to what other places, especially a city of the size of Wichita, does to do that kind of thing. There's not another case cited that kind of compares the facts to this one to establish what specific knowledge is. And really, the best we kind of work with are these general negligence standards that are enunciated in the pattern jury instructions of what constitutes implied notice for negligence. How long is something obvious before it's negligence on our part? And that's just a different standard than the gross and wanton negligence necessary for recreational use.
Thank you.
And that's really all I have, Your Honor, if there are any other questions. And thank you so much for having me.
And Mr. Benz, you have 3 minutes for Brett. I'm sorry, Brett. I need glasses on.
Thank you, Your Honor. The defendant's concessions were specific to this area.
Do you have a record site for that? I'm
I do. It's on page 3 of my appeals brief. And it's the testimony of Feist, it's the testimony of Steele and Russell, and then also Degenhardt. And then Degenhardt is the one who said, but the defendant never inspected it ever. The defendant did not even have an inspection program. The law requires them. And the PIC instructions, the comments talk about how this duty is non-delegable. This duty is mandatory, and it doesn't matter if they have the money or not. They have a mandatory legal duty to maintain it in a reasonably safe condition. They concede, and this is the testimony from Feist, Waddle, Steele, and Russell. They concede that it was dangerous, that this condition put people at risk of injury or death. The defendant did not respond. They didn't file a response to our statement of additional uncontroverted and controverted facts. And so under the rules, those things are deemed admitted. At the hearing, and I know the court has read this, but at the hearing, the defendant conceded wantonness, conceded wanton conduct throughout the hearing.
How did they concede wantonness?
He conceded specifically. So at the beginning of the hearing, the defendant.
Was this wanton conduct? And they said yes?
Yes. At the beginning of the hearing.
Well, that's a legal conclusion though. I mean, they can't see that.
A degree of negligence is a fact question. The definition of wantonness is a legal issue.
Right.
But the degree of negligence, including whether it is wanton conduct, is a factual determination. It is the ultimate determination that a jury would make.
Right, it is.
Yeah.
So you can't he can't testify to the conclusion of the jury.
Interestingly, there's a KSA 40-456 that says that an expert may testify in the form of an opinion.
Expert.
Yes. Yes, it was our expert. And I'm sorry, I probably can.
Sorry, I was.
Okay, so
that's the
your
city
expert
employee.
said it,
Yes.
Swanton.
Okay.
My expert,
Okay.
I'll go through it chronologically. My expert goes through all of this history
Right,
and concludes, his ultimate conclusion that this is wanton
sure.
gross negligence.
Okay. Thank you.
I include that in our statement of additional controverted and uncontroverted facts in my response to their motion for summary judgment. They didn't file a response. So at the beginning of the hearing on the motion for summary judgment, the district judge asked defense counsel, what about each of these additional statements of controverted and uncontroverted fact? What are you concede them? Do you admit them today? Do you deny them today? And defense counsel admitted almost every one. He admitted specifically the one that dealt with recklessness and wanton and gross conduct. Until the very end of the hearing, where the judge said to him, you've admitted gross negligence and wantonness. Don't you agree that I have to deny summary judgment because you've admitted this? He says, okay, well, maybe I need to change that. And at the end of the hearing, he changes. So he's conceded it throughout the hearing. He conceded all the way through until after I was finished being able to argue. And then the judge talks him into changing his concession and saying that this isn't wanton conduct anymore. But the expert, it's in the record already. And under KSA 40-456 subsection D, the expert is allowed to testify on the ultimate issue to be decided by the trier of fact.
I thought you were talking about the city employee.
Oh, yes. No, this is an expert witness.
Okay.
Okay.
And, you know, since the Kansas Supreme Court says that juries are supposed to decide the degree of negligence.
And that's your bottom line.
Yeah.
Shouldn't have been summary judgment. It should go to the jury to make.
Exactly. I don't need to argue anymore. Thank you, Ron. Thank you.
Both very much. An opinion out as soon as possible. Okay, and now the case name of the month. Beehive Honey Hole versus Rockin' Roofing Systems. Mr. Powell, you have 3 minutes reserved.
Yes, thank you. Are these bottled waters for?
Yes.
They are.
Please.
Thank you. I've been eyeing them.
Just
So let me have one of them.
Yes, please do.
Thank you very much.
Yeah, you can take one too.
Them are partially used.
I noticed.
I grabbed was.
That's not a good thing.
Oh, they are? Some of them have already been opened in there? Okay, well,
This one is fine.
okay.
All right. Thank you for
See, is that gross? Well,
that.
Gross.
it's gross. It is gross. Okay.
Very good.
Okay.
So may it please the court, as we've alleged in our petition and in our brief, this is a case about concealment and silence that should, by the defendant's insurance company and representative, which should not have resulted in the dismissal of our petition for failure to state a claim. Instead, the rules on notice pleading and 2 Kansas Supreme Court cases and some others should have allowed us to engage in discovery to show how the doctrine of equitable estoppel applies to bar the defendant's statute of limitations defense. We had this roofing collapse. We filed suit within 3 years under the COVID rules. It was more than 3 calendar years, but it was within timely. There's no dispute about that. And immediately at the end of March, and so I had April, May, and June to try to get Mr. Diaz served. And we attempted to serve him, tried certified mail. We sent the letter to his contacted his insurance company, sent them emails, asked for the address, and never got it. And so we're running into the 90-day deadline and then the 120-day deadline. So we issued a subpoena and they objected to the subpoena. And so the 120 days expired and we didn't.
So was there a hearing set on the objection to the subpoena?
No, there wasn't. Their objection was, well, you don't have a case going because you don't have service on the defendant. And so I made the decision, well, if the doctrine of equitable estoppel applies
as a defense to bar the statute of limitations defense, then it bars it whether it's in this suit or the next suit. So we refiled the suit and we got his address from the co-defendant's files, and were able to get him served. So he was served. And then they filed a motion to dismiss the petition on the statute of limitations defense. And we said, but the doctrine of equitable estoppel should toll the statute of limitations. It didn't matter if it was the first suit or second suit or when once there's tolling, there's tolling.
And is your argument that Shelter Insurance Company had a duty to tell you how to contact their claimant?
I'm arguing that
Isn't that kind
had
of
it-
weird?
they had a duty to speak when it or not remain silent. When the subpoena was issued, they had a duty. Before
And they
that,
met that duty by responding that, and there was never a hearing on that then? Wouldn't that be what you would do then? They would say, no, we're not gonna comply with the subpoena, so you would bring them into court to hash that out, right?
well, I looked at their objection. They said, you don't have a suit on file because there's no service, so you can't do this. And I thought, well, I'll get service, we'll find him. So I made that decision so we would have a hearing, and then we got service. So that became a moot issue.
And what was this argument in here? And I didn't bring my other notes, but that the 90 days had lapsed, that there was a lapse in the time before you requested additional time
Well,
to serve.
we felt that the request was timely within the end of the 90-day period, the way I counted it.
Okay.
They say we were a day late, but the district judge did issue the subpoena. And so the subpoena was issued, and don't believe that was the defense at the time to the subpoena.
Okay.
What's important here is the rules on pleading in petitions. We got the Zimmerman case that says when a district court has granted a motion to dismiss, an appellate court must accept the facts alleged as true, along with any inferences reasonably to be drawn. The appellate court then decides if those facts and inferences state a claim based on the plaintiff's theory or any other possible theory. This is really broad, favoring plaintiffs.
Mhm.
And then we have the Journal Broadcast case by the Kansas Supreme Court in 2017 that said courts must resolve every factual dispute in the plaintiff's favor. So what happened here, though, is the district judge said, well, you didn't allege that the defendant participated in this concealment or silence. Well, where is that written in the law that I have to allege that in an initial petition? KSA 6208 says notice pleading. The notice was in the pleading. Doctrine of equitable tolling applies. That was stated in there. Do I have to go through every element in a petition in order to survive a motion to dismiss with all factual details? No, not according to notice pleading. So it seems to me, with all due respect to the district court, they took the summary judgment standard, which is a failure to prove evidence on an essential point or essential element is fatal to a party's claim, and summary judgment may be granted due to the absence of evidence on an essential element. That's evidence. This was allegations. She said, well, you didn't allege this. Well, we alleged the doctrine of equitable tolling, and that should be sufficient. And so the elements were there, and in that national in that heading. Now, what's important here is even taking the judge's and I didn't see a case cited by the district court, but even taking that rule that she said, well, you should have alleged that the defendant himself participated in it. Well, we had no chance of discovery to do that. And I think the truth slipped out on page 11 of the defendant's brief, it says, even if discovery would have revealed that Diaz instructed Shelter not to provide his address to Beehive's counsel, what would that change? Page 11, that would meet the district judge's standard that she put on us, but we never found that. We asked, insurance company.
Do you think that is an element for this equitable estoppel claim to save the?
No, I don't. Under agency rules, there's one of the cases cited in the briefs talks about all the different types of agents we have under Kansas law, agency relationships, apparent authority, ostensible authority, implied authority. And with insureds and insurance companies, they have a contract, and the insurance company has a contractual right to defend their insured and a right to engage in settlement and a right to all sorts of rights.
Do they have an obligation, though, to help you with service on the insured?
I think they have a duty to speak when their silence is for their benefit. You see that? We had this $100,000 case. We just need good faith. Where does your insured live? We have not been able to find him. Oh, we're not going to tell you, and it's to their economic benefit. That does not seem good faith to me. It's not good faith. It's concealment of a material fact that stopped us from a timely suit. And if discovery shows what they say on page 11 of their brief, that they did that because they asked their insured, plaintiff's counsel wants to know your address. Will you provide it? And he said no, then he has participated in that.
I don't think he's saying in his brief that happened. He's
No.
saying if worst case scenario,
Right.
if this fact existed, it still wouldn't make a difference. Yeah.
Well, and it would.
I mean, that's his argument.
Yes, it would make a difference. And I'd like to see those claim notes and emails and phone logs to see if that's true. But as the Judge Hurst asked, that shouldn't be the end of our case again. That should be a still argument under the policy that they had the right to speak on his behalf. So when you have a right to speak on their behalf and you conceal a simple thing like an address to your own economic benefit, that's not good faith. That's concealment, and that's what the doctrine of equitable estoppel is all about. And so another important part of our case is this, well, they cite in their brief this Farrell case, which actually cuts in favor of the plaintiff, where in Farrell, they said, and I think it's on page 13 of their brief, the mere fact of remaining silent when possessing material knowledge not held by another is sufficient to toll the statute where the silence causes another to take timely action that they would not have taken. Here we attempted service at the wrong place, the wrong address. We would have gotten service at the right address in Arkansas, I believe it was. We finally found out from the co-defendant. So that case cuts our way. Another important point is the second argument in our brief about questions of fact. An agency relationship is a question of fact, according to this Barber Oil case in 1992, and it was cited again in 2014 by the Supreme Court in a case called, it's not coming to mind, but in that case, the same rule where the existence of agency is disputed. We say they're an agent, they say he wasn't. That's what we have here.
Question.
Its existence is a question of fact for the jury to be determined on proper instructions. But we don't even get there if we can't get the documents, the insurance policy, the claim logs, the emails, the payments. I'm sure they had the address. Did they contact him? Did they refuse to cooperate because the insured told him to remain silent? All of these factors are things for normal discovery that we didn't have a chance to do. So we just ask the court to reverse and let us engage in discovery and see what we can find.
Thank you very much.
Thank you. I'm gonna take my water. with
Yeah, don't put it
Yes,
back in there.
yeah, don't put it back in there. That would be gross.
I don't know if it
Okay,
does.
Mr. Kohler.
Oh, sorry.
That's okay, that's okay. Morning, may it please the court. Beehive's arguments at both the motion to dismiss and on appeal in their briefing in today suffer from two fatal flaws that can't be fixed, even if they're given the opportunity to do the discovery that Mr. Powell is asking for today.
Mhm.
First, as you alluded to, Judge Arnoldberger earlier, Beehive has not at any stage pointed to any law that creates a duty for an individual or an insurance company to provide a plaintiff with an address at which that individual can be served. And I know there was some discussion about, well, the subpoena creates the duty. I think in their briefing and at the motion to dismiss, it seems like there's two buckets. There's one where they're talking about the emails back and forth before the subpoena was issued. And then they're talking about after the subpoena was issued. And I think I'll go into both of those and why neither of those apply. But the other fatal flaw that they cannot get around, that we raise in our brief, is that this is not a contract case. This is a negligence case. There's no privity of contract between my client and Beehive. And what that means is that the lawsuit was barred by the statute of limitations 8 months before it was ever filed. And so we don't even have to get into any questions of equitable estoppel, any questions of the calculations of the 90-day rule and relating back. This was already barred. This was, as Mr. Powell alluded to, this is a case where the allegation is that my client, who's a subcontractor, piled roofing materials on a roof in a manner that caused the roof to collapse. There's no allegation that there's any privity of contract between my client and Mr. Powell's client. That is a negligence claim, and a negligence claim has a 2-year statute of limitations.
And the argument is he changed it to a contract claim in order to get within the.
Yeah. So I don't know why, but
I mean,
but yes.
it shape shifted from a
Yes.
negligence to a contract.
And it was never made it was never stated as a negligence claim because by the time it was filed, it was already barred by 8 months. My point is there's no contract claim here. It isn't.
Okay. Was it dismissed because there's no contract claim?
It was not, Your Honor.
Then that's not a question before us.
I believe, Your Honor, and we cite a case for this grounds, the Rose via Christie Health Systems in our brief that you can affirm on other grounds, right? Like a right decision, wrong read. Yep, exactly.
Right. But in order to determine that there was no privity of contract, there'd have to be a contract in front of a judge, et cetera, which is a hard thing to do on a dismissal.
Sure, there is no allegation that I think both in fact, there was no contract, but also there is no allegation in any of the 3 petitions that there was a contract between these 2 parties. So if the judge on a motion to dismiss is going to look at the facts in the petition and see there is no allegation that there is a contract between these 2 parties, look at the facts.
The motion to dismiss allege that?
No, it did not. We did not raise that.
Really?
And I think, Your Honor, there's a Court of Appeals opinion on that ground that it's State v. White, 51 Can-App 2D 1121, that discusses an exception to the general rule that a party cannot raise an issue on appeal that wasn't raised in the district court.
There's lots of, there are definitely exceptions.
But I think we fall into one of those exceptions. There's no question of, the one in the State v. White case, it involves only a question of law arising on proved or admitted facts that is determined on the issue of appeal. I think that applies here.
And did you raise that in your brief?
I did not cite the State v. White. I did not.
No, but I mean, did you say this is the first time on appeal and this is the exception we're relying on?
No, we did not.
Thank you.
We cited the Rose v. Via Christie, but not that issue. So even if we're looking at a 3-year statute of limitations,
or treating the claim as this, at least in front, at least for today's purposes, then they still have the duty problem, Your Honor. And so for the first bucket, if they're talking about shelter had a duty, when Mr. Powell was emailing them asking, shelter had a duty to respond. Where is the law that says an insurance company has a duty to respond, or even is allowed to respond on behalf of their insured and provide their insurance address for purposes of being served? And even if we were to concede, and I don't concede, but for purposes of these discussions, just speaking as if there is an agency relationship, and there's an agency relationship so close that we can treat my client as shelter for purposes of those conversations. I don't concede that, to be clear for the record, but even if that were the case, if Mr. Powell is trying to serve me with a lawsuit and calls me up and says, Jeremy, what's your address? I don't have any duty to tell him that. I don't have a duty to tell him when I'm going to be at work so they can find me to serve me. And there's no duty to either affirmatively provide your address so you can be served or respond to a question about it. Now, then the second bucket is the discussion of the subpoena. And as you also alluded to, Your Honor, shelter did exactly what it was required to by the subpoena. The subpoena said, answer these questions or provide these documents or object. And shelter objected and filed a written objection 4 days after the subpoena was issued. It didn't even drag out the timeline more than it needed to. And it filed timely objections with the court. And then, as you alluded to, nothing happened. There's nothing in the record to suggest that there wasn't even a meet and confer on the issue. I would not have been involved in that. I don't know either way, but there's nothing in the record to suggest that. There's no motion to compel, and there's no hearing on a motion to compel. Second, another reason.
And is your argument that that's essential for him to maintain that claim?
Yes. My argument on that is he's saying that shelter had a duty to respond, and shelter did respond. So does shelter have a duty to not object to a subpoena when a subpoena says you can object? And then if shelter does object and you don't file a motion to compel, is it then fair to place the onus on shelter that the objections must have been somehow wrongful or something like that? If you look at the subpoena, it doesn't even directly ask for the address of Mr. Diaz. Now, it asks for declaration pages over a number of years. In my experience, usually addresses are on those declaration pages. But my point is, if we're going to put all the eggs in the basket of your duty was to respond to this, you had a duty to respond to the subpoena, and if you had responded to it, we would have been able to serve you in time, then I don't think we get there when this.
Your argument is you responded.
Yeah, yes, we responded.
Fight is on, and he didn't take up the fight.
Yes. Now, finally, Your Honor, and you alluded to this earlier, the other issue with the subpoena bucket is the timing of the subpoena. So and I'm happy to go through, they're in our brief, and I know you guys are familiar with the records, but happy to go through it and just touch on it just in case there's any questions. So the subpoena, the first lawsuit, Beehive 1, which is the one we're talking about, the case number technically before the court is Beehive 3, but we get into the relation 6208, the relation back statute. So they need to show they commenced Beehive 1 timely. And so that's really what we're talking about. They filed that on March 30th. That is filed on March 30th, 2023. We say the 90-day, I think correctly say the 90-day deadline to serve Beehive 1 under 6203A1 was June 28th, 2023. Mr. Powell, I don't know if this was in the briefing, maybe I missed it, but mentioned today that he may disagree with that timing, but I don't think it matters if we are off by a day or two on that for purposes of the improper 30-day extension. And here is why. If you look at the Reed v. Miller case that we cite in our brief, what that says is that for the 90-day relation back, the extension needs to be, quote, sought and granted prior to the expiration of the original period provided by 6203A. And so the motion to extend it it was sought on June 29th, which we say is one day after the 90-day deadline. And then it was not granted until July 14th. And I don't think there's any question. I'm not the best at math. I have miscounted on occasion, but even if I miscounted somehow in the brief and it was actually July 29th instead of July 28th, June 28th instead of June 29th, it's not that there is no question that the 90 days had expired well before the purported 30-day extension was actually granted on July 14th.
So it's the July 14th, it's granted, and then that's when you filed your objection then?
We did not file an objection. Shelter had separate counsel that filed an objection to this subpoena. The court at the same time granted the 30-day extension. We say was untimely. And then although the subpoena was filed as a business record subpoena, which we also argue was improper because there were no parties on which it could be served, which is a requirement under 6245A. But in any event, the 14 days since the notice was filed had not expired. It was filed on July 14th. On July 7th. But on July 14th, the court both entered the 30-day extension and ordered that the subpoena be issued. The subpoena was actually issued on July 17th. Shelter responds on July 21st.
Okay.
So both, and the business record subpoena notice was not filed until July 7th. And I think that is also unquestionably after the 90-day deadline.
All of this was argued before the district court.
The 90-day issue on the motion to dismiss. No, the 90-day issue was not challenged on the motion to dismiss. That was raised in our brief, but I would go back to the same Reed versus Miller, right decision, wrong grounds issue.
But the district court ultimately issued the subpoena,
Correct.
although you contend wrongly.
But you get served with the subpoena and then you object is what happened.
Shelter got
served, then they file their objection.
Yes.
But not based on that. Based on the 30 days.
Yeah, not based on the time.
Yes, no, they don't. Shelter does not object based on the timing that I'm aware. I think there were. I don't have it in front of me. I think there were some of what Mr. Powell alluded to, some of those issues raised. I think there was maybe also an attorney-client privilege issue or something like that raised.
Okay.
The only other thing I want to touch on, Your Honor, unless you have any more questions, is if we then sort of take a step back and do dive more into the equitable estoppel issue and those questions, as we outlined in our brief, it is a very high bar to use equitable estoppel to prevent a statute of limitations defense. And we outlined that there's you need to, it essentially adds an extra element, as we cited in the Dunn v. Dunn case.
But is it being used to prevent a statute of limitations defense? Or is it being used to prevent a service defense?
Well, if it's being used to prevent a service defense, that would be something that I am not aware of this court or the Kansas Supreme Court ever recognizing before, because all of the situations in which it has previously been used for the statute of limitations are issues of the substance, where something about the substance of the claim was hidden. For example, I think the one that jumps out to me, I think this is the Robinson v. Shaw, like the doctor left something in during surgery and then didn't saw the x-ray and didn't tell the patient. And so all of these are substantive. So as far as our research was able to reveal, this would be the first time that it has been used in a Kansas appellate court to get around service. And I'm not saying
Had a motion to dismiss. To get around service. Yeah, okay.
And I'm not saying it's impossible to come up with the factual circumstances in which that would exist. And maybe in this case, for, you know, how, I don't know how you come, the problem you're going to continue to, sorry, am I open?
No, okay, go ahead.
Yeah,
The problem you're going to continue to run.
remember, I'm bad at it. I'm good at it. Okay, go ahead.
The problem you continue to run into is that you would continue to run into if applying it in service cases is that there's no, where's the duty? When do you have the duty to provide information so you can be served?
Well, that would get figured out. That would get sorted.
Yeah,
Wouldn't get you out of, you know, being served.
yeah, yes.
It would get sorted.
The duty to provide the duty to provide information so you can be allowed to be.
Yeah.
Yes, and I don't think we come anywhere close to that in this case where, and on the notice pleading, I appreciate and don't disagree that we have notice pleading in Kansas, but there's a difference between saying, well, I don't have to list out every single element. I think that's different than you have to include the facts in your petition that support the element. You don't necessarily have to say this fact supports this element, but as Judge Bolton Fleming noted, there were facts that are an absolute necessity for this estoppel defense that were simply not in the petition. But as I mentioned previously, we don't even need to get to the question of allowing discovery to get into that because there is no duty. And this is a negligence case and was thus barred by the statute of limitations. Otherwise, I'm happy to answer any more questions, but we stand on our brief.
Very much.
Thank you, Your Honor.
We let him go over so you can have 5 minutes instead of 3. How's that?
Thank you. So about half of that argument was on things that never were addressed to the district court or in the motion to dismiss. It seems like defense counsel enjoys making me look bad. That's his motive. I don't know, or just coming up with whatever arguments he could. But the truth is that this was filed as a breach of an implied covenant of good workmanship claim. That's a 3-year statute. I knew it was 3 years when we filed it within the 3-year period under COVID rules. I didn't use the word negligence in the petition on purpose. I didn't need to. I had a 3-year statute. We just needed to get him served within 90 or 120 days.
Tell me what impact do you believe or what importance we should put on the fact, if any, the fact that you tried to get this information from Shelter, which is the basis of your equitable estoppel claim. They wouldn't provide it. They object to the subpoena, which they're entitled to do, but then you don't do anything.
Yeah, what I was trying to explain before, maybe I didn't do a very good job, is the doctrine of equitable estoppel, when it bars a statute of limitation defense or service defense, it bars it. So if we would have had a hearing and got the address, we'd have still been beyond the 90 or 120 days by the time that occurred. And we would have been arguing the same thing that we argued in the new suit, is that the doctrine of equitable estoppel allows us to proceed, and they can't use the 3-year statute as a defense in the 90-day rule because they concealed and were silent, or they got their insured's permission not to give out his address.
And that would,
So it's the same result.
in order for that to apply, though, they would have had to have had a duty to do something prior to the subpoena.
Well, the way I see that is, can't find a case that says you have a duty to give an address, but when you're requested to do it and you're silent and another party is detrimentally harmed by your silence, there's consequences to silence.
Okay.
Maybe there's no case that says they have a duty to give me the address, but that by being silent and not cooperating and not acting in good faith, their silence gives rise to consequences for the doctrine of equitable estoppel.
So help me get through this procedural steps. You've got Beehive 1, you're trying to get him served. Shelter's not being forthcoming. and the subpoena is filed in Beehive 1, correct?
Yes.
Okay, so the subpoena is filed, they object. And then Beehive 3 or 2 or whatever is the one that you make the equitable estoppel argument in. You
Initially,
wouldn't have made that in 1 because you didn't have it yet.
yeah, initially what happened is we filed Beehive 2, and the defendants, with that equitable estoppel argument
Okay,
in it. But the defendants objected, oh, you can't sue in the name of Beehive because their corporate status got revoked. And so
so there was a different problem on Beehive 2.
procedure one, so the judge said, so I'll
We're
just.
not dealing with that.
Yeah,
We're not dealing with that.
not.
Okay,
So we,
Beehive 3.
yeah,
You make the equitable estoppel claim. I guess my question is, what was your duty to get that resolved in Beehive 1 when you had an opportunity to get the issue resolved? What,
my duty was to use good faith efforts for my client to try to get the defendant located and served, and
and you did,
I-
and you did, and they objected. Don't you have a duty then to get, I mean, we can't assume they were objecting in error. Because they, as he said, they did what they were allowed to do, which was you served them with a subpoena and it said you've either got to provide the documents or tell us why you're not. And they filed a motion telling them why they're not.
a court approved and ordered subpoena, and then they're silent. I think there's
They're
consequence.
not silent.
They, about the address.
Subpoena.
Yeah,
No, but I mean, they object to the
They-
subpoena. If I'm a business and I get a subpoena, I don't immediately have to turn that information over. I can object and have a hearing on whether I have to. And wouldn't it be your responsibility once they object to make, or maybe it was their responsibility, to get a hearing date set to get an order from the court? I mean, what they were doing, I'm assuming, is a motion to quash the subpoena.
yeah. So that
And
is,
so,
sorry.
okay, so am I way off track here or?
Well, I think the answer to your question or point is that case stayed on the books.
Beehive
Was
1?
pending during Beehive 2 and 3, and then got dismissed when we got service under Beehive 3. So we didn't, the need for a hearing to get the address from Shelter got resolved when the co-defendant provided the address to me right after we filed.
But then you're going to be using this as equitable estoppel to get you past the statute of limitations problem.
We couldn't get him served in that 90 or 120 days because they were silent,
Okay.
and they may have had the defendant's cooperation. This all
Okay.
comes down to,
It's complicated.
I think it all comes down to what does the petition allege under the Zimmerman case, and do those facts create on their face, state a claim on that theory or any other theory? And
So regardless of what factually happened, as long as you pled it, that's it.
yes, Zimmerman and the Journal broadcast case, and we're in court, and we've got to now do discovery and survive a summary judgment motion. That's what I thought was going to happen, but we never got to that.
Right, I get it. Okay.
Yeah.
Thank you very much.
Thank you, Your Honor.
We appreciate your arguments. We'll take the matter under advisement. We stand in recess. Our Wyandotte County docket is over. And the 2 research attorneys, if you want to come on back with us for a minute, that'd be great. Yeah. Yesterday.